So we're going to go through the step-by-step process, and then I encourage you to refer back to this when you're on your own and you're filling out the paperwork. First, we're going to talk about the different forms that have to be filed, and then we're going to go through those forms individually. So if you have questions about the forms, wait till we get to that form, because we may answer your question when we get there. Write it down so you don't forget, and then wait till we get to that form. So the very first form that you're going to be filing is the application for appointment as guardian advocate. Okay, so that's Form A. Now, if you are a husband and a wife, or there's more than one person who wants to be the co-guardian, you will print that form twice, and you will each fill out an application for guardian. So anybody who wants to be guardian needs to file an application. Okay? So, and that application for appointment as guardian advocate is all about you. So all the information in there is all about you. Your work history, your address, your date of birth, your social security number. You do need to put that down. You must list all the information. If you don't fill it all out completely, they're going to kick it back to you. We're going to talk a little bit as we go on. That information does get redacted when it gets filed with the court, and there's a form that you fill out to tell them what pages need to have information redacted. We'll go through that in a second, okay? So Form A is the application for appointment as guardian advocate. The next form, Form B, is the application for determination of civil indigent status. That is so you can get the court to waive the fee, the filing fee, which is $405, and the court-appointed attorney fee, because when you file for guardianship over your child, the court appoints an attorney to represent their interests. Because remember, we talked about due process. They get to have somebody represent them to make sure that this is in their best interest. And that person usually just goes out to their home, visits with them before the hearing to make sure, everything looks good, and then comes to the hearing. And because you are, if you're filing on your own, represented on your own, they'll probably also be the ones to answer the questions or ask the questions at the hearing, which we're going to talk about in a minute. All right, so the application of civil indigent status is all your child's information, but you are signing it at the bottom. Again, we're going to go through them individually. You are signing it at the bottom with your name, your driver's license number, and your address, and whatever other information it asks for, okay? But it's all about the child. Their financial, are they working? Do they get SSI income? Do they have any assets? Because this is telling the court they have nothing, so you need to waive those fees. Because normally, those fees would get paid out of the assets that the ward has. So we're telling the court there are no assets, okay? So it's real important to fill that out, because that's going to save you about $850, almost $1,000. All right, the next form, Form C, is the waiver and consent. If you are husband and wife and you are co-guardians, you don't need to worry about this form. But if it's only one person filing to be guardian, one of the parents, then the other parent needs to sign this Form C, waiver and consent. And that is so that they are aware the guardianship process is happening, and they are waiving their right to be the guardian advocate and allowing the parent to serve as the guardian advocate. Yes, ma'am?
And what if they refuse?
What if they refuse? So if they refuse to sign the waiver and consent, there's a whole process we're going to go through that you have to serve them formally, okay? Another common question I get is, what if mom or dad is no longer in the picture and we have no idea where they're at? Then you have to publish you have to do a publication notice that the guardianship process is happening and show that you have tried every which way but loose to find them and you can't find them. So there's also a form for that to fill out. That form's not actually in this packet, but it's on the Clerk of Court's website. Yes?
To serve them, I have to have an attorney to do that?
No. No, you can do that on your own. Yeah, you don't need an attorney to serve them. If you're filing guardian over the person, we kind of walk you through what to do.
And what if I don't know their home address, but I know where they work?
You can serve them. If you don't know their home address, but you know where they work, you can have them served at work. As long as you can show that they were served, because you're going to have to do that by certified mail, and you're going to have to file a return receipt that they were served.
If they are
If you are in different counties, can both parents still serve? Yes, I have parents that live one parent lives out of state and the other one is in Hillsborough County, and they can serve together, absolutely, yeah. And also, if they are, if they're in a different county or in a different state and they can't make it to the hearing, they can ask to attend by phone, and our court is usually very good about that. Yes, sir.
On the previous Form B, if both parents are co-guardian, do we need to fill out 2 of those forms?
That's a good question. I'm glad you brought that up. So on the previous Form B, the application for determination of civil indigent status, yes, both parents need to fill one out. Even though it's about the child, both parents do need to sign off on it. So you print 2 out, and because there's only enough room for one person to sign and give all their information.
Okay.
Yes. Okay. All right. So yes, ma'am.
What if you have a parent and then you have a friend that's not a parent? They will still sign as both in co-guardianship?
If they're both going to serve as co-guardians, they both need to fill out the application and the civil indigent status application. But again, what I need to stress with you is, so if it's the parents who are serving as guardian, and you've got one that's not serving, you have to get a waiver and consent or serve them. Or if they've died, you need to file a death certificate to show that they're dead, because the parents have the priority to serve as guardian advocate over their child. So we need to make sure that that's clear. Yes, ma'am.
Okay, say I'm married, my husband and I both fill out separate applications.
Yes.
But say we have another adult child, can there be a third person, just in case something
That's a
happens
good
to
question.
us?
So we have parents who want to serve, but there's another adult child. Do we want them to serve as a co-guardian with us? There's a form in here. You can name a standby guardian, and that's in most cases that's what I would recommend you do. But what you need to understand about that's just basically informing the court, this is who we want to be the guardian next. If they've got a felony, they're not going to be able to serve. And they are going to, when it's their time to take over after mom and dad have passed away, or if mom and dad become incapacitated, they still have to file an application. There may not be a hearing, and that's just up to which county you're in, but they still are going to have to file an application and something to tell the court, okay, they've died, here's their death certificates, now I'm taking over, in the credit report, whatever. There's some hoops they're still going to have to jump through. Even though you've named them as the standby guardian advocate, it's not automatic. Okay? Good question. All right. So then we have the petition for appointment of guardian advocate. That's Form D. That's the big one, okay? Because that tells the court everything they need to know about you and your child. The petition is what you file to tell the court, I want to become my child's guardian advocate. Here's why. Here's all the relevant information you need to know, and here are the rights that I want to have the decisions to make for him or her, okay? So that's the petition. Again, we're going to go through it in just a minute. Form E is not, well, actually, yeah, there is a form in here. Form E is the report of the attending physician. So if you, yeah, there is a form in here. So if you already have a report from a doctor that says what the disability is, you can submit the doctor's report. It has to be a doctor. It can't be a nurse practitioner. It needs to be an MD, okay? And if you've got something that says what the diagnosis is, you can submit that. If you don't, because quite often, especially when the kids are older, you may not have something that says that it dates back to before their 18th birthday. Some of them are obvious, like Down syndrome obviously happened on or before the 18th birthday. Excuse me? Can we use that? Yeah, well, if you don't have a form, then there's a report of the attending physician in a Form E that you can give to the doctor to fill out, and then you can submit that.
Can we use a report that's like...
That dates back from before the 18th birthday?
Can you use a report that dates back from before the 18th birthday? In Hillsborough County, I would say yes. I don't know about other counties, but yes, in Hillsborough County you can. As long as it shows the diagnosis of what they have. Because then that will establish, too, that it was before the 18th birthday. Yes, ma'am?
My daughter's been diagnosed with 2 disabilities, so would I need
So the question is, her child has been diagnosed with 2 disabilities, and do you need information from both doctors? That's a good question. Usually in the doctor's report, most doctors will list everything. So it doesn't matter that the diagnosis came from 2 different doctors, as long as you have a report that lists what everything is. And as long as the developmental disability is referenced in the report, the one that we're relying on, that's part of this, Florida statutes, that's all you need. Okay? All right. So Form E you won't need if you already have a doctor's report, because you're going to just use the doctor's report. Next is Form F, and that's the Oath of Guardian Advocate and Designation of Resident Agent. This is the only document that has to be notarized, and the oath is you telling the court, I will fulfill my duties as guardian advocate, and I am able to serve as guardian advocate. You are representing to the court that you meet all of the requirements as outlined in the statute, i.e. you're of sound mind, you're over the age of 18, you don't have a felony conviction. Okay? And so we'll go over that in a second. That one does have to be notarized. And if you are co-guardians, then each person has to sign an oath. Okay? So you're going to print those twice. You've got the application for guardian advocate, the affidavit of indigency, and this oath. Those each guardian needs to have one for themselves. And then we have the credit report of the guardian. Well, that's not a form because you have to run your own credit report. Each guardian must run their own credit report. Form G, Notice of Confidential Filing Information. So remember I said at the beginning, your application, it does ask for your Social Security number. The petition asks for the child, the adult disabled child's Social Security number. And this notice that we sign, this Notice of Confidential Filing, is our way of telling the court, there's some confidential information in here that you need to have redacted. And so they will redact that so it doesn't show up in the public records. Okay, and we'll go through that form in just a minute. The notice of the petition to appoint guardian advocate. So Form G, when we get to Form G, those are all the forms that are going to get filed with the court to open up the file. Okay, so that's everything that you need, except for maybe one more, Form P, the notice of filing. We'll get to that in a second. But pretty much Form G and above, that's everything you need. That's the packet that you are going to take to the court to file, to get the whole process started. The rest of the forms that are listed in here, with the exception of one I'll talk about later, the rest of the forms are going to happen after you've filed the petition. And we're going to go through what that process looks like after I go through all the forms. So the notice of petition to appoint the guardian advocate, when it gets to the point that you are having a hearing, this notice is going to get, if we've got both parents serving as co-guardian, then the notice is going to get served. Typically it's read by the court-appointed attorney to the adult disabled child. Okay? And I might slip up sometimes and use the term ward. And they are known as the ward because they're a ward of the state. If one parent is not going to serve, then this would be your notice that you're going to serve on the parent that is refusing to sign the waiver, or you can't find them, or they're giving you a difficult time. You're going to file that notice and serve them with that, along with a copy of the petition. Then we have the notice of hearing. So if you are doing this yourself, it is your job to file some of these things with the court. So one thing that I really, really want to stress is, if you have questions about any of these forms, do not call the clerk's office to ask them a question, because they cannot give you legal advice. So refer back to the video. Or, you're going to have to figure it out yourself, but do not call the clerk's office, because they cannot give legal advice, and they will tell you that. They won't answer the question. Do not bother the judge's judicial assistant, because, again, they cannot give you legal advice, and they will tell you that, and you're on your own. You need to figure it out yourself. And believe me, anybody can do this, because we've been doing this workshop now for going on almost 2 years, and we've had lots of families come back to us and say, we did it. We did it. You made the process easy. And I had one family who spoke nothing but Spanish. So if they can do it, anybody can do it because these forms aren't even in Spanish. They did have somebody that was English speaking kind of helping them out, but they were able to do it. So it can be done on your own. I know it's overwhelming, but if you take your time and you just go through everything, if you follow our instructions, you can do it. So this notice of hearing, it's your responsibility to call the judge's office when the time comes, and we're going to talk about when that time is right. Call the judge's office and get dates from them, and then you're going to coordinate the hearing date with the court-appointed attorney. So you're going to make sure the court-appointed attorney has the right date, has an availability. You've got the dates from the clerk's office, and then you're going to fill out this notice of hearing to submit and file with the clerk's office. The order appointing guardian advocate and the letters of guardian advocacy you will file with the court whenever they want. Generally, it's right before the hearing. You might bring the forms with you to the hearing and enough copies so that they can sign off on them and give them to the court-appointed attorney. You get one. The order says we are appointing this person to be the guardian advocate, and here's why. And the letters are your authority to act. The letters of guardian advocacy are your authority. That's the piece of paper that you're going to take to anybody that says, how do you have the right to make this decision? I got letters. Okay, so you're going to get a certified copy of those letters once the court has signed off on them. We'll talk a little bit about that. And then finally, Form L and Form M. So after you've become appointed, on whatever date those letters are dated, the letters of guardian advocacy, your authority, you have 60 days from that date to file an initial plan with the court. And that plan, we're going to go through it, that plan simply tells the court what kind of services they're receiving, medical services, personal care services, where they're living, what the plan is for the next year, what you're going to do for them for the next year, and why this is a good thing. And there's little there's little examples in there, so they kind of give you an idea of what it is they want. Okay, the initial plan gets filed within 60 days, and then a year later you have to file an annual plan. It's a little bit more comprehensive. It's several pages long. But once in Hillsborough County, once you've filed the initial plan and the annual plan, the court will generally let you file a simplified plan every year thereafter. And it's 2 pages, and it is very easy, but you have to file it on the anniversary date thereafter. And when the court sends you the order, because they will send you an order approving the plan that you filed or disproving it and say we need more information. When they send you that order approving it, they'll tell you next year this is when you file it between this date and this date. Okay? So they make it fairly easy for you. In other counties, they may require you to file the annual plan. So again, it depends on county to county. If you're in another county, you need to ask your judge what you can do, the following year. But that annual plan then needs to be filed within 90 days of the anniversary date of being appointed the guardian advocate. So if you hire an attorney, if you hire our law firm, because I can't speak for every attorney, we will stick with you from the beginning when we file all the way through the annual plan. So we will help get you through and get that annual plan filed a year later, and then get the court to enter the order that says now you can file the simplified plan, and then we get out, because then you don't need us anymore. You can file that on your own. Okay, so, and I can talk to you guys more about that afterwards if anybody wants more information about that. All right, the miscellaneous forms that you need to be aware of. If you want somebody to be named as standby, then there's the application for appointment of standby guardian advocate. There's a joinder that they will sign off on when you file the petition. So that's for the standby guardian. And then finally, there's a notice of filing. So remember I said up through Form G, that's your whole packet of what you file. The Form P is going to kind of go along with that, because the notice of filing, if you have a death certificate for a parent who has passed away, if you have your own doctor's report that doesn't have a case, it doesn't have the case style on it, so the information that's at the top of every pleading that you file. If you have, your credit report, you're going to do a notice of filing with those documents to say these documents are attached. And the reason we do that is so because you're going to see in the forms there's a case style at the top on every pleading, and we don't have room to put that on the doctor's report or on the credit report, so we put that notice of filing with it. The next part of this is the actual, what are the next steps that you have to take. So we kind of talked about that already. You're going to file your pleadings with the court, and then you have to send the notice to the parties. So for the parent who didn't sign the waiver and consent and for the ward, because the ward is entitled to notice of this, you're going to be serving the notice to them. And this just kind of goes through and tells you what do you need to send. You need to include the consent, you need to include the petition for appointment of guardian advocate. I would include a cover letter stating this is why you're receiving this, and that's what you're going to send to the parent. This does say you are going to serve all next of kin. So if all you have are the parents, that's all who's required to be served, even if there are adult children. But if both parents are gone and we've got a sibling, or if maybe a sibling is filing and one of the parents is still alive, then generally, again, you've got to serve the parents, and you might be also serving, if it's a child that's going to act as the guardian advocate, you're going to serve any other adults that are any adult children, any next of kin. If you're serving by certified mail, so for those who are serving a parent, let's say, that is not cooperative, if you're serving by certified mail, you want to file the proof of service with the court, so the green card with the court, stating, I've served them, here's proof that I've served them, and you want to do that. They have 20 days to respond, so you want to file that, and generally the court won't set a hearing until that 20 days is up, because they want to give them a chance to respond. All right? Once you file, you're going to get a case number. Okay, so you won't have a case number initially. When you file, you will get a case number that's assigned to you. You're going to, if you file, you're filing everything at once, typically, unless you've got the certificate, the certified mailing that you have to file later. For anybody who's like a mom and dad that are filing together, you're going to have filed everything. I'd probably give it about, a good 5 business days before I then call the judge's assistant. And right now, those names are listed in the packet. Really, only one of these magistrates is doing all of the guardian advocate hearings now. Is that right, Dana? Yeah. So Judge Cadigan, Magistrate Cadigan, Sean Cadigan, is who you're probably going to get. Used to be Magistrate Reeves also, but she's doing other types. She's doing more family law stuff now. So right now, I think we only have one magistrate that's handling all the hearings. So. But when you file, you're going to get an order that says who the judge is, and then you can refer back to this so you know what their phone number is, right? You're going to get the order that says who the judge is and who the court-appointed attorney is with their information, so you'll have their phone number. So then you're going to call the judge's assistant, and you're going to say, okay, I've filed my paperwork. You're going to give them the case number. They'll look it up, and then they'll let you know, yes, everything's in the system, or no, you still need XYZ. If everything's good to go, then they'll give you some dates to be able to, they'll probably give you a choice of 3 dates and say, these are the dates we have available. These are the times. You call the court-appointed attorney and you say, these are the dates the judge has available. These are the times. Which one works for you? And then you guys pick a date. And then you'll be filing that notice that we talked about earlier, the Form H. And that states what judge we're in front of, what time, what date that gets served on everybody. I would call the judge's JA about a week before the hearing and say, okay, we're planning on being here on this date. What do I need to bring? And sometimes, well, when we're representing, they want us to submit the order and the letters online. when you're filing on your own, I don't think you have the ability to do that, at least not yet. So they'll probably tell you either mail them in or bring them with you to the hearing. And that's a question you can ask the JA. What do you want me to bring? You know, what do I need to bring to this hearing? It's not a legal question. It's something that they can certainly help you with. And then you're going to attend the hearing. You want to get there. It's safe to get there, 30 minutes before the hearing starts, so you can find your way in, because you got to go through security and go through, the pat down thing. In Hillsborough County, the hearing is on the 4th floor of the courthouse, and when you get there, you'll let the judge's assistant know, I'm here. And then the court-appointed attorney will let them know they're here, and then they'll call you in. And the hearing itself takes no more than 10 minutes, usually. And if you're represented by an attorney, the attorney is going to ask you some questions. If you're not represented by the attorney, Magistrate Cadigan, there's a procedure he likes everyone to go through. He'll either ask the questions or the court-appointed attorney will ask you questions. The questions that are asked are not anything you don't already know. It's about who are you, what is your relationship to this person, what is their disability, those types of things, okay? So just listen to the question and just answer the question. You don't need to throw up at the mouth, just answer the question that's asked of you, and that's all they're needing. And if the judge has anything additional, he or she will ask you questions too. They will introduce everything in, the doctor's report and your application and everything as part of the record, and you will then be told, okay, I'm going to recommend that you are the guardian advocate. Now, one of the things I didn't point out, the magistrate is not the actual judge, okay? There's a judge over the probate court that signs off on everything. So the purpose of the magistrate's job is to do the hearing and make recommendations to the court. So generally those letters and orders get signed fairly quickly when we're doing everything online. I don't quite know how quickly they do it when it's just you filing on your own, but they're probably going to get signed at the very latest within that week that you're there. And you'll get letters, you'll get them either emailed to you or mailed to you, conformed copies. Once you have the conformed copies from the court, then it's going to be your job to request a certified copy. So you can go directly to the clerk's office and get a certified copy of the letters, so that it's stamped by the clerk's office. This is a certified copy. The judge signed this, and that's your authority to act for everything that you want to do. Okay, but it is important to have that certified copy once you're appointed, because everybody who wants to see it, the doctors, the schools, are going to want a certified copy. So that's pretty much it. There's just some do's and don'ts and how to act in the courtroom. Do wear your best Sunday clothes. Don't wear cutoffs. Don't wear, crazy stuff. Wear your best Sunday clothes to the hearing. Just wait for the judge to talk to you before you say anything. And again, be quiet, listen to what's being said, answer whatever you've been asked, but you don't need to volunteer any additional information. And once you're done, you get up, say thank you, and you can leave the courtroom, and then that's it. And usually, if you're doing it on your own, the court-appointed attorney will certainly probably be able to answer, any general questions you might have, like when is that initial plan due again? They can tell you when that's due.
So is it a large court or is it just a chamber?
It's just, the question was how big is the courtroom? So in Hillsborough County, it is a very small chamber. Well, it depends on which judge you're in front of, but it's a small room. It's definitely not as big as this. There's not going to be anybody else but you, the court-appointed attorney, and the judge in there. And another thing that a lot of people ask is, well, does our child have to come with us? If they're in school, and if it's a hassle because you've got somebody who's wheelchair bound and it's just a hassle to get them in and out, You can ask the court-appointed attorney, because remember, the court-appointed attorney represents your child. Can we waive having the child there? And once they've met with the child, they usually will tell you, yeah, that's fine, that's not a problem. In very rare instances do they want the child to be there. So you can ask for that to be waived. So it's just you and the court-appointed attorney. Yes, ma'am.
When you file, when you're granted the guardianship, how long is that valid for? Like, because when you have to submit the simple.
Right, so the question was, when you're granted the guardianship, how long is that valid for? Well, the guardianship is for their lifetime, okay? You have to file that plan on an annual basis as their guardian, period. When somebody passes away, somebody else needs to take over. But I don't know if that answers your question. The guardianship is for their lifetime.
What happens if a simplified plan is not followed up every year?
What happens if a plan is not filed every year? So right now, the way our court handles it, I believe, because I don't have that problem because we make sure they get filed. I haven't had one yet. If it's not filed, they're going to do an order to show cause and say you need to file it by this date, or you need to come in front of the judge for a hearing and explain why you haven't. And if you don't go to the show cause hearing and fail to file the plan after that, you'll be removed as guardian and you will no longer have the right to make any decisions. And then you're going to have to go back in front of the court, and they're not going to be happy with you if you have to refile and get started again. Yes, ma'am.
For those children who are still in school after 18, do we need to show this paperwork to their school?
So the question was, for those who are still in school, they're over 18 and they can usually go to school till age 22. Do you have to show this paperwork to them? Yes. The letters of guardianship, that's your authority to act. So that's what you would show to them so that you can get into the IEP and your certified copy of the letters of guardian advocacy, yes. Okay.
Is guardianship valid throughout all 50 states?
Another good question. Is guardianship valid through all 50 states? So your guardianship that's filed in Florida is valid here, okay? If you decide to move, you have to notify the court here that you're moving, and you will have to get the guardianship established wherever you move to. Now, not every state has this guardian advocacy process that we have. In some states, like Ohio, I'm licensed in Ohio, so I can talk about Ohio, does not have guardian advocacy. They just have guardianship, period. So, and their process is going to be way different. So it's a good idea if you move to talk to an attorney in the state that you're going to find out what the process is. You might need to hire an attorney, you might not. In some states they let you file the guardianship without an attorney, but you do have to move it because remember you're filing, the statute says if you take them, if they leave the state or leave the adjoining county, I forget, for more than a certain number of days, then, and you change their domicile, you have to notify the court that they are moving. And you're going to be notifying them at the very least in the annual plan or the subsequent simplified plan because it asks for where are they living now. So when the court sees, oh, they're not here anymore, then they're going to come back to you and say, you need to get the guardianship established in the other, wherever you've moved to.